This is Colin O'Keefe checking in for LXBN TV. For a long time, businesses have pushed for EPA regulations to be more practical, based a little more in common sense and less in minutia. But when they finally do, the courts shut them down. Joining me now on LXBN TV to explain what happened and if there's any solution is Fred Wagner, formerly Chief Counsel of the Federal Highway Administration and now an attorney with Beveridge Diamond and author on the firm's blog, Envirostructure. Fred, first, can you explain the basics of the ruling? I know this is something you wrote on, but just to frame it, what exactly happened here for those of us who don't know?
Sure. Thanks a lot. The Environmental Protection Agency a few years ago decided to give a little bit more flexibility to local municipalities and cities in doing what's called transportation conformity. And that's the part of the Clean Air Act that says that when a locality does a plan to include a various number of transportation projects, it could be highways or transit projects, they have to make sure that in doing so, they meet air quality standards set by the EPA. And so a few years ago, EPA said, hey, we're going to change our standards for a particular pollutant, ozone, and we're going to give the locality some more flexibility to meet those standards by saying that, hey, the old one, back from 1997, you don't have to meet that. Just meet the 2008 new standard that we're setting, and you'll be fine. So they tried to give localities more flexibility, but the EPA was sued by the Natural Resources Defense Council, who said that they couldn't do that under the law.
I see. And then second, the thing that you wrote on again is that people tell the EPA to be a little bit more practical when it comes to these things. They try to be, and then they get shut down for it. Is there any kind of workable solution here? What really is the answer if, even when they try, they get shut down?
Well, I mean, it's a great challenge for EPA because politically, they're in a very tough situation. People from Congress and from the states, governors sue them all the time for failing to be flexible, for failing to give them a chance to comply with the law. And in this particular case, the NRDC decided to try to sue to stop EPA's interpretation to make it more strict. I think what parties can do in these situations, you have to realize there's an opportunity in the rulemaking process to let your voice be heard. And a lot of times, folks who really want more flexibility just say that they need it, but they don't explain why. And in this particular case, I think some of the cities, some of the states could have been a little bit stronger in the comment period to explain to the EPA and to give them a record to defend, to say, look, this is why we need flexibility. We're not getting around the law. If anything, we're going to comply with the higher standard that you're setting in 2008, and here's how we're going to do it. And then this way, EPA could have gone to the court and said not only, hey, under the law, we think we have this flexibility, but you know what? The regulated community, they asked for this. And not only did they ask for this, but they've demonstrated why it won't harm the environment. And I think what EPA did is they went to battle with kind of one hand behind their back. They felt that, hey, we're doing the right thing. We're trying to be more flexible. We're trying to give a more expansive interpretation of our rules that we think people will like, but they didn't have a lot of the support in the record to demonstrate why. One of the interesting things, Collins, to note is that this was a case that had a 2-to-1 split in the DC Circuit. There was a pretty strong dissenting opinion that said, hey, wait a minute. We should be deferring to EPA. If they say this is a good thing for the environment, why are we telling them now that you have to have this ultra strict interpretation of the Clean Air Act when no one's really demonstrated that this is going to be a real problem? And if anything, the dissent said your ruling in the majority by making this strict interpretation means that these localities don't know what to do. Do we comply with the 1997 standard or do we comply with the 2008 standard? And if so, how do we choose? Those are some big challenges that I don't think the majority really understood. But a lot of it could be solved by parties putting more information in the record demonstrating why flexibility is a good thing, both from a policy perspective and from an environmental perspective.
Absolutely. It's advantageous to be proactive on these types of things. And really what you describe is just getting out in front of these so you don't have to be reactionary later when it comes to a lawsuit and that type of thing, because ultimately it's going to help you in the long run.
Well, that's right. And I think sometimes you have to think a little bit about what the challenge is going to be in court 2 or 3 years later. And it's hard to think that way sometimes. But if you can imagine making an argument in front of 3 judges and saying, hey, here's why this makes common sense, and be able to put those kind of things right there in the docket in the Federal Register, well, then that makes the job for the Department of Justice and the EPA that much easier. And they can insert some more common sense into these regulations, which at the end of the day, I think it's what everybody wants. Coming from inside the administration, I know how we struggled to get regulations through the Office of Management and Budget because they asked those tough questions and we had to demonstrate why our rules made common sense. So this is a situation where I think the advocates who wanted this flexibility needed to do a little bit more earlier on to put that good information in the record for the government.
Absolutely, absolutely. Once again, that was Fred Wagner of Beveridge and Diamond. To read more of his insight on this particular case and other issues in environmental law and associated topics, be sure to visit Envirostructure.com. Thank you for joining me today, Fred.
Thank you, Colin.